thank you very much to the organizers of the conference. So the goal of my presentation is to examine the scope of European institutions and regulations on issues confronting religious principles with sexual issues. The main question I want to set is if we can affirm the existence of a European sexual democracy based on the decisions and policies of the European institutions. So, to do so, I share my current postdoctoral research on sexual politics and European institutions, and my methodology is based on three main corpuses. The first one is the case law of the European Court of Human Rights. The second one is the European Union secondary law, composed mainly by European Parliament and European Commission resolutions. And the third one is national specific cases and documents that I will present here. So, in the first place, I will define what is sexual democracy and what is the scope of freedom of religion in the European document and system, juridical system. Then in a second time I will present some of the major cases that illustrate the dilemma I discussed here. And finally, in a third time, I present some of the lines of study that I'm working on this issue. So what is sexual democracy? We heard Eric Fasson in the morning, and he was the first one who defined the term, the notion. For instance, in this article of his, who is from 2006, he defined it as a process of extension of the democratic domain with the growing politicization of questions of gender and sexuality revealed and encouraged by current public controversies. Later, he enriched the notion and in his later works. So, Fasson defines it in two main ways. The first one is as a historical process of increasing politicization on issues previously considered private or natural, questions of sexuality and gender. And the second is as a discursive tool, mobilized in controversial and political issues such as immigration, equal marriage, etc. So, while the first definition is useful to analyzing historical tendencies and geopolitical trends in various societies, the second perspective, on the other hand, might function as a normative parameter that evaluates and classifies societies by distinguishing civilized and communities as more respectful of new sexual rights, new sexual freedoms, from the other, more barbarian, more ancient, or attached to traditional values and sexuality norms. So, in other words, it's a rhetoric of otherness that is declined according to racialized and orientalized, in some cases, typologies. What is freedom of religion? Well, you might know that freedom of religion is mainly enshrined in the European Union Charter of Human Rights. It's in its article number 10, that it's freedom of thought, conscience, and religion, and in the European Convention on Human Rights, that is the Court of Strasbourg, mainly on the Article 9 and the Article 2 of the Protocol 1. So, for example, Article 9 establishes this: the right to conscious religion, to change religion, to manifest your religious practices. But it is the second part which matters the most to these presentations, and I tell you why. Because it states that freedom to manifest one's religion or beliefs shall be subject only to such limitations as are prescribed by law and are necessary in a democratic society. This is my emphasis. This is important because in the court case law, democracy is then set up both as an ideal political regime and as a regulating principle in controversial and contentious cases concerning fundamental rights. So it is precisely this link between democracy as a regulating principle and the actions taken by European institutions regarding sexuality and gender issues that I want to address here. Given that, according to court jurisprudence, three values characterize a democratic society according to the court, and these are pluralism, tolerance, and openness. The definition of these values is fundamental to understand how European institutions understand and interpret the controversies on sexuality issues. That is, which discourses underpin the production of policies and law enforcement regarding these issues. So, the study of the European Court of Human Rights archives shows how these values are reiterated in several cases, such as the promotion of various forms of pluralism and with the direct and different effects on gender and sexuality cases, relations in Europe. So, for example, religious pluralism is described as vital to the survival of a democratic society and has been invoked to deny the protection of the convention to Muslim parents refusing to send their daughters to mixed swimming lessons on the grounds of their faith, in a case versus Switzerland. But also educational pluralism has been invoked as essential to the preservation of a democratic society, and it was used to defend sex education against parents who were Christians, who were mainly Christians, and who didn't want their kids take classes of sex education. So, European institutions, such as the European Court of Human Rights, have been at the forefront of arbitrating contentious issues on sexual rights and freedom of religion. We must ask then, which is the dilemma that I am referring to? If we define the dilemma as a situation where we have to choose who is correct, what justice has to define which right is protected under the legal and European order. So the cases of the European Court of Human Rights are a good example and a really good object of study to understand if sexual democracy exists as a model in Europe. So, since I don't have much time, I will only present the major cases that I have been studying. The most ancient case is on Denmark, the Jeltsin case, where three couples of parents maintain that compulsory sex education introduced into state schools in Denmark was contrary to the beliefs they hold as Christian parents, and that the sex education violated the Article 2 of Protocol number 1. What establishes this article? Well, it establishes that the state must respect the right of parents to ensure the education of their children in accordance with their religious and philosophical convictions. What happened in this case? Well, the court established that there was no such a violation because Articles 8, 9, and 10 of the Convention proclaim the right to everyone, parents and children, to private life, to information, and information included sex education. But the court went further and established that sex education is an issue of public interest. And this is important. Why? Because it goes against the distinction between the public-private that is inherited from the modern times in liberal states. So, sex education does not affect the right of parents to enlighten and advise their children to, in the same sense of the parents' religions and convictions. That is to say, school fulfill a function, but you as parent in your house can say to your children, maybe, don't listen to the teacher, he or she is not right. That's your function as parent. And this case established jurisprudence in several cases that I have been studying. Thus, I already said that. For example, in the Dogen case versus Germany, that it is also on sex education, but this case provides richer information on the connection between the local, the national, and the European level. Why? Because this case was also several couples who were against sex education. They were Christian Evangelical Baptist, and they established that there was a violation of their right as parents to against their religious conviction of sex education. But here the local government, the local German courts held that the parents' right to educate their children and the right to freedom of religion is restricted by the state mandate to provide for education, which was implemented by means of compulsory schooling, evidently. So this mandate was not limited to the transmission of knowledge, but also aimed at educating responsible and emancipated citizens capable of participating in the democratic processes of a pluralistic society with a view. So we see again the value of plurality, pluralism, as major for democracy. You can see what established the national German education law on the matter. And as you see, which parents were against were the argument of a liberal way of understanding sexuality of the sex education state. And also the mention of sexual orientation and identity in the law. So the court again decided that there was not a violation, and it decided that the convention does not guarantee the right not to be confronted with opinions that are opposed to one's convictions. We pass to another case, the Ossenamblu against Switzerland. It is the case that I told you about the Muslim parents on swimming lessons for girls. So in this case, the court ruled that Switzerland had not violated the right to freedom of religion by refusing to grant an exception to 2 Muslim girls. But this case is really interesting because of the discursive shift of the Switzerland state. Why? Because the federal institutions, the Federal Supreme Court of Switzerland, ruled in the opposite direction in the 90s. And it said that the pupil's interest, the best interest of the child, was to prevail in relation to his or her parents' religious interests only and only where the child's best interests were tangibly and seriously compromised by strict adherence to religion rules, which was not the case with the swimming pool lessons. What happened 15 years after 2008, the Federal Court of Switzerland goes against herself, against the same jurisprudence, and says that the interest in ensuring integration, that is the most interesting, at least from my perspective, is that integration and compliance with the values of the local culture, that is, with Switzerland culture, ought to be given greater weight. Then we have 2 Russian cases that are really worth of attention for the use of religion as an argument against sexual freedoms and for the instrumentalization of international legal order by the Russian authorities. Following repeated bans by the Russian government on the organization of pride marches in several towns within its territory, the Russian Federation was taken to the European Court and to explain the violation of freedom of expression from several citizens. Russian government relied on the International Covenant of Economic, Social, and Cultural Rights, the Internal Covenant on Civil and Political Rights, to the protection of the religion of the population, the Russian population, and moral beliefs, the right to bring up their children in accordance with them. The mayor of Moscow again stated that gay parades were absolutely unacceptable in Moscow and in Russia, unlike some Western country more progressive in that sphere. I end the quote. So this illustrates the common representation of a clear distinction between West and East, or between West and the other countries, the periphery, or as a geopolitical division. And one of the most interesting features of the Russian cases is the summoning of this international law. These are some of the arguments of the Russian government that defended that the state must take into account the requirements of the major religious association, and the democratic state must protect society from destructive influence on the moral fundamentals. In the second case of Russia, one of the arguments was that since we are dealing with the best interest of the child and the children, then we have to give parents a major participation and their right to parents. But the court shows too some of the dissenting opinions, which tell us that right inside of the European Court, of the European institutions, are people who disagree with a dominant perspective of European institutions. What about other policy actions on the European institutions, on this confrontation between sexuality and religion? Well, we have the Parliamentary Assembly of the Council of Europe, published in 2010, that established that member states may grant exception to religious institutions and organizations when such institutions and organizations are either engaging in religious activities or when legal requirements conflict with tenets of religious belief. So I remember you that we have two different regimes here. We have the European Union regime and we have the Council of Europe regime. Why this is important? Because Russia was part of the Council of Europe. That was why it was an attribute of the European Court, the Court of Strasbourg, to call Russia to account on the European human rights. And the most recent European Parliament resolution towards an European Union strategy on the rights of the child established this, that it calls member states to act against honor crimes, homosexuality, and also names the swimming on cultural grounds not justified by any culture or religion. So I want to conclude with my lines of thought, given that this is a work in progress and I'm starting my postdoctoral research. The distinction between a sexual free West and the backward peripheries found in some cases, such as the Russian ones, where you define the West against the East, coincide in some points with works that have proposed notions of homonormativity. I think in Lisa Duggan, on homonationalism, I think in Jasper Poor, and sexual imperialism, for example, Joseph Nassau. Insofar as the discursive consolidation of what democracy is for Europe, how Europe defines democracy as a geopolitical space, and how it defines sexual freedoms, distinguishes how individuals may conduct their ways of life. In these ways of life is included religious practices. And if these practices are protected and legitimated by the European legal order, the European human rights order. So what I have found until now is that the notion of sexual democracy is not just an articulation of a political regime, in this case democracy, how the European institutions define democracy, and a human aspect of potentiality of sexual issues, gender, but also is the implementation of historical and political principles that are geographically and historically rooted. So this temporal and spatial materiality has very real and concrete effects in local contexts and for actors fighting against or for concrete forms of life that are translated into freedoms and for example, education of children, the use of the veil, or organizing gay pride events. So, the human rights juridical and judicial discourse has consolidated sexual democracy as a political standard whose elasticity allows the Council of Europe, the European institution, the European Union, member states to use it in cases where a confrontation of rights and freedoms arise. And if European institutions must take side in this controversy, as the cases of the courts shows it, it is not a coincidence that they do so in favor of a specific, postmodern, Eurocentric, and liberal way of life, since this is a consequence of historical and geopolitical processes very deep-rooted in the Western world. Thank you.